On this video, we are going to analyze the civil procedure question from the July 1996 California bar exam. This question, I assume that you have read the question and given some thought to it. I hope you have. You get more out of the lecture if you have. In any event, to make the lecture complete, I will read the question, then we will do the analysis. Danco, first paragraph. Danco is a manufacturer incorporated and headquartered in state Y. Pat, a state X resident, had been employed as Danco's state X salesperson from 1985 to 1995. In 1994, Tom, a state Y resident, was hired by Danco's sales manager. Tom works at Danco's headquarters in state Y. New paragraph. In 1995, Tom increased sales quotas and exerted pressure to reduce lead times from initial contact to final sale. Pat's protest that this would ruin long-standing customer relationships was ignored. Despite several warnings to increase sales, Pat failed to meet the new quota and was fired on his 50th birthday. New paragraph. At the time of termination, Pat had several large deals pending, and Tom promised Pat he would receive his standard commission for those sales if they were completed. Danco, however, ceased doing business in State X during that state's due to that state's unfavorable business climate, and the sales were never completed. New paragraph. After fruitless attempts to find another job, Pat sued Danco in State X Federal District Court for breach of a federal age discrimination statute and breach of contract based on failure to pay $30,000 in anticipated commissions. The district court granted Danco's motion for summary judgment on the age discrimination claim and dismissed the breach of contract claim for lack of subject matter jurisdiction. Pat then learned that two prospective State X employers had refused to hire him because of negative references provided by Tom. Pat sued both Danco and Tom in an appropriate State X court for age discrimination under State X law, breach of contract for the unpaid commissions, and defamation. New paragraph. Both Tom and Danco appeared specially and moved to quash service. The court denied the motions. The defendants answered and filed motions for summary judgment, claiming the federal judgment was a bar to Pat's claim. The court denied these motions. New paragraph. State X law provides that in courts, its courts may exercise jurisdiction over non-residents on any basis not inconsistent with the U.S. Constitution. Then we have two calls to the question. Number one, assuming the defendants were properly served, did the State X court properly assert personal jurisdiction over each defendant? So we ask, did the state court properly assert personal jurisdiction over Danco and over Tom? The second call of the question is, in federal court, is the federal court judgment a bar to any of Pat's claims against either defendant? This question obviously involves a fair amount of material on personal jurisdiction. So let's do a quick run-through, quick review of the law of personal jurisdiction. On the lecture tape, of course, this is covered much more thoroughly, so I will be brief here. Personal jurisdiction has three requirements. a proper basis, a long-arm statute, and notice. Now we're talking about personal jurisdiction over non-resident defendants. If the defendant is a resident in your state, you don't need a long-arm statute, of course. If they're a resident in your state, then of course the basis is domicile. But we're talking about those cases when you need all three of these problems. Comes up when you're in California and you want to sue a defendant in Texas, and you want to get jurisdiction to make that Texas defendant come back here and defend. So for that, you'll need a sufficient basis. Sufficient basis means that the Texas defendant has enough contacts with the state of California so that it is fair play and substantial justice to make the person come back from Texas to defend. Do we have an adequate basis for jurisdiction over the defendant? There are two classes of adequate basis. They are the traditional basis and the modern ones. The traditional basis on which a court could exercise jurisdiction over someone are domicile. Of course, if someone's domiciled in your state, the court can exercise jurisdiction over them. Present when served, or consent. The more modern, non-traditional, recently developed basis for jurisdiction are these two: systematic and continuous activities in the state, and minimum contacts. Under the minimum contacts, there are three requirements and one factor. The requirements are purposeful availment, nexus, foreseeability. Then if you have these first three, the court will then look to see if exercising jurisdiction over this defendant would be fair. These are discussed, of course, more fully on the lecture tape. The purposeful availment is asking, did the defendant do something that where they have taken some benefit of the state? If a person from Texas comes to California and hits your car in California, well, they've come here and used the roads. And then they go back to Texas, you can make them come back here and defend. If the person from Texas comes here and builds a bridge or a house or a building or something, and then they go back to Texas, well, they've come here and they've performed a contract in California. That's enough contacts with the state to make them come back here, and they can be sued here about that contract in California. So you look for the contacts that the person has had, is that enough contacts so that you look for to see if in their contacts they have purposely availed themselves of some of the benefits of the state. And you look under purposeful availment, don't forget that you are looking at the substantiality of the contact. For example, if I send 2 pencils to Massachusetts from California, that's not going to be enough to make me go to Massachusetts and defend if those pencils punched out somebody's eyes or something. On the other hand, if I send one $100 million turbine to Massachusetts and something goes wrong in Massachusetts, of course I'll have to go there and defend. In both cases, I purposely avail myself of the benefits of Massachusetts because I sold stuff in their state and got money back from them. And selling stuff to the citizens and getting money back is considered purposeful, is a purposeful availment. In one case, however, the purposeful availment was substantial in the turbine case, but the purposeful availment was very minimum in the pencils cases. So purposeful availment, you have to look to see how substantial the contact was. Also, don't forget, when you're looking at the substantiality, was that purposeful availment at all, and how substantial was it? Also look at the nature of the contact, because if I ship a box of pencils that cost $20 to Massachusetts, and if I ship a box of dynamite that cost $20 to Massachusetts, you can see that the likelihood that I may have to go to Massachusetts and defend because someone got hurt is going to be much higher in the case of dynamite than it is in the case of pencils. So you look at the nature of the contact, the magnitude, the substantiality of it to answer these questions. Nexus is just asking the question, did the cause of action arise out of the contacts? Foreseeability, would a reasonable person in the defendant's position realize that if they do what they're doing, they may have to go to that state and defend? And the fairness, as we talked about on the regular lecture tape, you look at factors such as the convenience of the parties, the location of witnesses, the location of evidence, that sort of thing. Now, and so that is a summary of the law of personal jurisdiction. And now let us look at the particular question that we have and apply those rules. The first call of the question is, does the state X court have jurisdiction over Danco? Well, to get personal jurisdiction over Danco, we just said requires a basis, a long-arm statute, and notice. In the case of Danco, Danco is a statewide corporation, and we're trying to get jurisdiction over Danco in state X. And so we cannot do it by domicile or present when conserved or consent. So we're going to have to get jurisdiction of a Danco based on some of these modern techniques if we can establish them. They gave us the long-arm statute. It was a coextensive with the U.S. Constitution type long-arm statute, and there's no problem regarding Danco getting the notice. The problem has to do with the basis, and does Danco have enough contacts with state X to have to defend in state X, and we're going to have to use these. So systematic and continuous and minimum contacts. Well, can we get jurisdiction over Danco based on domicile? The answer is no. Can we get jurisdiction over Danco based on systematic and continuous contacts? Well, make an argument, because Danco, systematic and continuous contacts generally means that the defendant has employees or personnel who are systematically and continuously present in that state, in the forum state. And here Danco is a statewide corporation and at least had one employee consistently in state X for 10 years, apparently doing a fair amount of business because he's got $30,000 coming in commissions. And so it looks like that at the time that the cause of action arose, that Danco had systematic and continuous contacts with state X. So you may be able to get jurisdiction over Danco in that way. If not, you would then resort to the minimum contacts and you would look for purposeful availment. Did Danco purposely avail itself of the benefits of state X? Yes. They had an office there and so forth. Did the cause of action arise out of that? Yes. Foreseeability? Yes. Fair? Yes. So discuss those and put them all in there. That gets you your jurisdiction over Danco in state X. The second call of the question is the jurisdiction over Tom in state X. The jurisdiction over Tom in state X, again, you can't get general jurisdiction over Tom in state X because Tom is not domiciled in state X. Tom is a state Y person. So Tom is not domiciled there. Tom, there is no consent, and Tom is not present when served in state X. So the general jurisdiction over Tom in state X is no. Specific jurisdiction, based on minimum contacts, we're going to have to look at each cause of action to decide that. You can't just look at all the causes of action collectively together because the facts are different regarding each of them. Regarding the defamation, can we get specific jurisdiction over Tom in state X regarding the defamation? Well, I don't think so, and this should require some discussion. I don't think that Tom has purposefully availed himself of any benefits of State X. He doesn't live there, he didn't go there, he just sent some nasty information there. And so it's unlikely. On the other hand, you can say that even though Tom did not reside in State X and doesn't have any other contacts with State X, that he did send us defamatory material into State X. And so you can argue that he committed a tort in State X because that's where the harm occurred. When you defame someone, you can argue that the tort occurred at the person's place where they sent the defamatory statement or at the home where it was received. So you can claim that Tom committed a tort in State X, but it's a problem here because if Tom simply followed company procedure and sent out, the company mail or something of that sort, or sent the personnel file, and the personnel file was defamatory, I don't think that Tom himself is liable for that because he was really just acting as an agent for the principal, and unless he added some malicious material to it, he simply sent the file or some part of the file to the prospective employer in State X. And so I don't think you can get personal jurisdiction over Tom based on defamation because Tom did not purposefully avail himself of the benefits of State X, and the foreseeability probably would fail. On the age discrimination, certainly Tom is not personally liable. You can't get jurisdiction over Tom regarding age discrimination because that's something the corporation itself would have done. Again, Tom did not purposely avail himself of any benefits of the State Acts, and the cause of action for age discrimination did not arise out of any of Tom's connections with State X, and so you won't be able to get jurisdiction over Tom regarding the age discrimination because he doesn't have any contacts with State X regarding that. And the breach of contract, where Tom is not even a party to the contract, so that's going to be a no also. This one required some discussion. So jurisdiction over Tom. The next problem is they ask about res judicata and collateral estoppel against Danco and against Tom. Again, you're going to have to look at these in terms of each of the causes of action in the contract. With regard to Danco, the breach of contract, well, the federal court dismissed the case saying we don't have any jurisdiction over the breach of contract case. And so there's no res judicata or collateral estoppel regarding the breach of contract because nothing has been decided. Age discrimination, well, again, the case was dismissed in federal court based on summary judgment. But we're now in state court, and the law of age discrimination in federal court and the law of age discrimination in state court, even though they have the same name, could be very different laws. And so decisions which are made at the federal level regarding age discrimination are not necessarily applicable to a state action. However, please notice that if in the summary judgment regarding the age discrimination in federal court, in that summary judgment proceeding, if there were some factual decisions made that were contrary to the plaintiff's position, if there were some factual decisions, then those decisions are the plaintiff, Pat, would be collaterally estopped to deny those decisions which have been ruled against him, even though it was in federal court. But we don't know that any factual decisions regarding age discrimination were made against Pat. Defamation, probably no, again, because first of all, the defamation suit was not brought in federal court. It was only brought in state court. I don't think there was a defamation suit in federal court at all. We'll look at that to be sure. And the facts say that in the federal court that Tom brought an age discrimination and breach of contract. He did not bring the defamation suit in federal court at all, so there's no res judicata or collateral estoppel that would apply there. Against Tom, no res judicata because Tom wasn't even sued in federal court, and collateral estoppel, again, the age discrimination and the federal law on age discrimination and the state law on age discrimination are not necessarily the same law, so there'd be no application of those principles there. That answers all of our questions. The first call of the question was about jurisdiction, and we talked about that. And the second call of the question is about collateral estoppel and res judicata. And the main trick there is that a lot of people took age discrimination, since there was a federal age discrimination law and a state age discrimination law. They treated them as identical, but of course you can see they have identical titles, but that's about all. That is the end of the analysis of this question.